is a first.
Welcome to MsMojo, and today we're counting down our picks for the most inexcusable and out-of-touch excuses defendants brought to Judge Marilyn Milian's courtroom.
You're like, well, it was both. I just didn't want to say that, so instead I admitted to criminal action. There's something off.
Number 10, big heart, no license. Sharon Stevens is probably one of the most lovable defendants to come through the People's Court.
And I had just gotten sober, and so they told me that I had to have a payee.
Stevens' sister-in-law sues her for getting into a car accident with her car and unlawfully filing a claim. Stevens, on the other hand, claims she's been paying insurance every month, so she shouldn't have to cover the cost. In response to the judge asking her whether she's ever been in an accident, Stevens drops this fun little tidbit.
Never been in an accident in my life.
Well, how long have you been driving?
For a long time. I drove for about 20 years without a driver's license.
She did pay for the tickets she got as a result, though. We don't know that this part of her defense helped her win the case, but the judge did rule in her favor in the end. Not that she realized right away.
Verdict for the defendant.
I'm the defendant.
Number 9, I don't care.
I need you to stop with the bobbleheading. You're annoying me.
Two former friends end up in court over an unpaid phone bill. Defendant Brandon Bojorquez Gonzalez's reason for not paying up made him sound more like a middle schooler than a grown man. Every defense sounds more and more petulant. According to him, the plaintiff was jealous of his new friends, and he couldn't get in touch with her because she shut his phone off.
I don't know her number, and I didn't have a phone.
I live down the block from him.
Seriously, how do you put one foot in front of the other and not, just get run over by a car?
Eventually, it starts to sound more and more like he's lying, and he can't even really be bothered to lie well. The worst part is probably the end, when he tries to act smart with Doug Llewellyn.
You kind of come off as you don't really care. She did you a huge favor.
I don't care.
Number 8, bad memory. Defendant Dorothy Hensey is the last person who should be all that stands between a pit bull and the innocent public.
There were cops all over the place when your dog bit this guy? Because she doesn't look like a guy.
So
you
I guess
thought
I'm
she
not
was
the first
somebody
person.
else who apparently also got bit by your dog.
Right.
Her dog has attacked enough people that she actually thought the lawsuit was a man from another case, which made her defense that the plaintiff grabbed her butt fall apart immediately.
I totally forgot. I totally forgot.
How do you forget that your dog attacked another human being?
Moving from one airheaded excuse to another, Hensey finally settles on "I forgot" as an excuse. Her demeanor suggests that she either won't or can't understand just how bad this could have been.
Why? Why is that okay? If that was your arm, would that bother you?
Yes.
When do people have to stop getting bit by your pit bull?
That doesn't cut it for the judge. If anything, it makes it worse that she can't keep the dog attacks straight. Number 7, lazy framing.
I don't believe you. I don't even understand why you're going through these Herculean efforts. Sometimes accidents just happen. I probably think the reason why is because you don't have insurance.
Plaintiff Richard Paul Sparks II was involved in a hit and run with defendant Tamara Lynn Gould, whose defense is pretty damning. She claims Sparks was driving under the influence and tossed a bottle of alcohol from his car after the accident. Judge Milian has trouble believing that the bottle, which Gal has brought into the courtroom, is genuine.
You have a bottle for me today?
Yes.
Yeah, may I see the bottle? Okay, and what's that a bottle of?
Hennessy.
Hennessy, and that's the bottle he threw out of the car that magically didn't shatter.
She figured Gal was probably uninsured and tried framing Sparks to get out of paying. This becomes even more reprehensible when we learn she tried to use the plaintiff's previous DUIs against him, despite his 8 years of sobriety, and doesn't even remember saying this in her answer to the complaint.
I have 2 DUIs in my background.
Okay.
One in 94.
Which is exactly what you said. You don't remember saying that?
No, I don't remember saying that.
Okay, that's magical.
It was all a lot of effort for nothing. Number 6, just a helpless old woman.
To have his signature on it.
Oh, I didn't know that.
Really?
The plaintiff bought a car from the defendant, who later repossessed the car when he couldn't keep up with payments. However, for that to happen, defendant Sandra Demore would have had to forge his signature on a title.
The only way they could have done that is if you forged his signature and said, I repossessed the car, here, put the title back in my name.
Demore tries to portray herself as a weak, vulnerable old woman who's afraid of the plaintiff, and even tries to gain sympathy for having deceased children. But none of this changes the fact that there's no way she could have repossessed the car without forging the plaintiff's signature. Demore also admits to going to the plaintiff's property herself a few times with the aim of repossessing the car herself, so the helpless card isn't really working for the judge.
Please don't play that card because you're repossessing stuff in the middle of the night. You are the most fierce 70-year-old, so don't play the victim. I can't stand that.
Number 5, no warranty.
So who at your dealership thinks that I am an idiot?
Reynoso is exactly the kind of used car salesman that keeps court shows on the air. He's smug and self-assured, but once the evidence piles up against him, he's speechless.
Where is his signature at any point in time? Is there a signature?
We have his signature on the bill of sale, which is
Well, that's
submitted.
a signature. You do understand that that is one legal document and this is another one, right?
He insists that the warranty the plaintiff tried to use had been purchased, but the only record of the warranty doesn't have the customer's signature on it. He has an elaborate story about the way the company does business, and Judge Milian lets him spin his wheels for a bit before ultimately dropping the bomb on him. There is no warranty filed with the company he's been telling her about. She already checked.
Because, see, I took the liberty of calling Penn Warranty Corporation before coming out here. And you know what the funny thing is? They don't have a contract for him.
Watching the defendant silently crumble as she finds out he just pocketed the man's money is exactly why we watch these shows. Number 4, sorry not sorry. We've seen our fair share of remorseless litigants, but this defendant is in a league of her own. Defendant Stephanie's audacity is almost impressive.
How long you been using men like this? Always?
No, not really.
I don't know whether to think you're a terrible person. I probably do.
She's upfront about why she accepted all his gifts and pretty much admits to taking this guy for a ride. And she can't even stop herself from smiling the whole time because she knows how it sounds, but just doesn't care. This guy didn't get anything in writing, so there's really no proof that the gifts and money he gave her were really supposed to be loans she'd have to return.
That's what makes you believe there's a Rebecca? She promised
Let me ask you a question. Why
Let me
did you
ask
pick
you a
name
question.
like
Why do you
Rebecca?
believe there's a Rebecca?
While her excuses might be bad, there's not a lot the judge can do without proof, so she ends up ruling for the defendant.
It's still not going to happen because you don't have any proof that you did anything but sugar daddy the hell out of this. So you reap what you sow.
Number 3, deny, deny, deny.
Why won't you give him his security deposit back?
Your Honor, I'm not familiar with this gentleman.
It's not clear whether her flat effect is a sign of exhaustion or just apathy, but the landlord in this case has a pretty novel excuse for not paying the plaintiff. The apartment the plaintiff is suing her over was never rented to him, but to someone else.
I don't have any evidence or memory of him giving me any money.
She says the pictures he brought of the disgusting basement apartment are not even from her unit. Of course, none of this holds up once the judge sees evidence that she accepted payment from him.
Talk to me. Defend yourself.
Your Honor, I'm not sure what property that is.
Even after she loses, Roberta still denies being at fault. Number 2, keeping her safe. When the plaintiff's troubled daughter came to the defendant and told her she was being abused, the defendant's motherly instincts kicked in.
I thought I was keeping her safe. Because
Why?
Because she told me she was being abused.
Melinda McManus hid the teenager, who was her son's girlfriend, in her house for 6 days, all the while police scoured the surrounding areas. During this time, the plaintiffs had no idea whether their missing daughter was even still alive.
I thought she was gone.
I'm sorry. Did you tell that to the police?
No.
There is clearly some messy family drama involved on both sides, but that is neither here nor there when it comes to defendant McManus's weak reasoning that she thought she was keeping the girl safe.
Why did you lie to the police?
I thought I was keeping her safe.
Over and over, you lied to the police. Each day they came to your house and you lied. When did you find out that you were harboring a missing child?
It doesn't hold much water when you consider there were SWAT teams searching for her at the time. Before we unveil our top pick, here are a few honourable mentions. Texting and bike riding, a defendant lies about how an accident happened.
Well, you think she just made that up and you didn't say it? Sweetheart, you're under oath. And you have an opportunity to be an example for other people right now.
I am doing everything I can. A landlord lets her tenants sit in 19-degree weather without heat.
What you needed to do was shell out some money. No, not a month later. You needed to be on it because you have a requirement under the law to provide heat.
Something borrowed, something stolen. The defendant tries to dismiss that the plaintiff made a pass at him by confessing to an illegal drug deal.
You would rather not say that and say the weed deal because the weed's illegal.
Before we continue, be sure to subscribe to our channel and ring the bell to get notified about our latest videos. You have the option to be notified for occasional videos or all of them. If you're on your phone, make sure you go into your settings and switch on notifications.
Number 1, I just built the website.
I've seen some of these sites, and I know that you saw that it was a personal smear campaign.
The plaintiff, whose advocacy against child abuse has apparently made him many enemies, finds himself the target of a vicious and disgusting online smear campaign, and he's suing for defamation. Enter the defendant, the man responsible for building the website that hosted edited pictures of the plaintiff and allegations of sexual abuse against him.
This is not me. This is what my clients wants to put. This is not my website.
Right, but your client doesn't put it on, you put it on.
The defendant's pathetic excuse that he was just doing what he was paid for and therefore isn't responsible makes the judge as irate as ever. Here's an expensive lesson about having a good moral compass, folks.
You are the quintessential definition of a guy controlling the content that goes on. And you can get sued for defamation.
Which of these excuses made you roll your eyes the hardest? Tell us in the comments.
Did you just hear yourself? How many times has your dog bit someone?
Do you agree with our picks? Check out this other recent clip from MsMojo. And be sure to subscribe and ring the bell to be notified about our latest videos.